Welcome back to Law and Crime Network, keeping the peace. It is July 13th, 2020. Rayshard Brooks case. Let's get back to this. This is the one where the taser was taken from the police officers as he was running away and the police officers were in pursuit. He turned around and fired the taser. The police officers then shot. One officer shot and killed him, is now being charged with 11 counts, including felony murder. The interim police chief in Atlanta has already had harsh criticism of the district attorney's decisions in this case, and he actually went to the news and spoke a little bit more about it. Let's take a listen.
What we do want is a level of due process as it relates to how investigations are handled and how we are criminally charged.
You saying charges were brought too quickly in the Rayshard Brooks case?
Absolutely. I think that anytime the Georgia Bureau of Investigation is conducting an investigation, and for us to get all the facts, that's in our line of work, that's what we have to do. We have to make sure that we have all the facts or enough facts to warrant charges.
All right, I have with me Gene Rossi, a legal analyst at the Law and Crime Network, DOJ, 30 years, awesome trial attorney. Gene, let's get right to it. This interim chief has been thrown into the hot water with this case because the chief resigned, the initial chief, after this incident, and from the beginning has been critical that the district attorney has politicized this and went ahead of the Georgia Bureau of Investigation, did not wait for a full investigation before charging. What are your thoughts?
Well, here's the problem with this prosecution. The DA seems to have a conflict regarding funds that he received for a nonprofit. That's number one. Number two, it seems to have violated protocol. Number three, and this is more important, Bob, he's in an ethical cesspool right now because he issued grand jury subpoenas that appear to be invalid. So he himself, the DA, is under investigation for violating grand jury rules. So it's just a total mess. And the only way to cure it is to get somebody else to take over the investigation.
Yeah, we're going to get a little bit into that subpoena issue and a grand jury subpoena issue in a minute. But Ross' attorney, that's the officer, it's indicated that in any other circumstance, this was a forcible felony. He's going to the law. In other words, there was force being used. It was a lawful encounter by the police, that the victim is the one who escalated the situation. When he actually took the taser from the officer using force, which would be the definition of a robbery, and then turned around and pointed that and fired it at the officer, that there was a lawful use of force here. And I think what this interim chief is trying to say, whether you agree with that or not, is that when you go so quickly, Gene, when we've talked about this so many times before, when the district attorney is so quick to be out in public and doesn't follow the actual guidelines that are normally followed, which is wait for the investigation to be completed, you have now opened the door for defense attorneys to say, you are just going after to hang this cop because of the court of public opinion. Thoughts?
Here's my thoughts. In this case, they had 8 videotapes from what I read in the material that I was sent to me. They had plenty of evidence to find a probable cause to charge Officer Rolfe. In these other cases, the Armand Arbery case, they only had 1 video, and they really didn't have enough evidence to charge quickly. Here, I think they had enough to charge. You're right, they didn't follow protocol, but those videos are pretty darn devastating.
Gene, just real quick, this is what the deadly force basics of that statute are, because it's important to understand what the law is when you're applying the facts. And if an arrested suspect, a felon, poses an immediate threat of physical violence to officers, physical violence, not necessarily death, or to protect himself or others from life-threatening injury, or to prevent a forcible felony. What I'm trying to say here is that the defense of the cop in this case is going to be that even if it was just a taser and the officer knew it, he could have been incapacitated and therefore he was no longer in control of his weapon if, in fact, he didn't think that it was an actual gun being fired at him. At least, would that be a defense you would try to pose? And would you argue the law? You know what they say, Gene, right? If you have the facts, pound out the facts. If you have the law, pound out the law. If you have nothing, just scream and yell. What do you think?
Here's my view. Is it beyond a reasonable doubt? Does the officer have an argument to make before a petit jury, a jury at trial? Yes. But looking at that video, if you freeze frame it, that officer had to know that all he had in his hand was the taser, which is not a deadly weapon. He pointed it at the officer. Then he started running away. There is no officer expert who's going to say that deadly force was appropriate when he turned away and started running away from the officer. He went beyond the standards that he would need to respond to that threat.
My bet, Gene, is they will find a use of force expert that will testify on behalf of the defense. We will have to wait to see that unfold. But to your point that you raised earlier, this prosecutor's actions, I was one, you were one, but when you are the head of the office and the head of the agency, you have to act in an impeccable fashion so that your investigation and your agency is protected from undue criticism. Now, you mentioned some money payments that have been part of an initial investigation for some time that were supposedly diverted back to this district attorney, but there's also an issue in the Rayshard Brooks case itself. Let's make sure our audience understands. A grand jury subpoena is issued by the grand jury. The grand jury is really controlled by the court, and the prosecutors are invited in to present cases to those grand jurors, and they get to issue the powerful, powerful grand jury subpoena. The only problem here, Gene, was there was no grand jury impaneled at the time the subpoena was issued. So it was an unlawfully issued grand jury subpoena. He's being looked at for that. And this is District Attorney Paul Howard that I'm talking about. Let's take a quick listen to at least some of the statements he's made in public before we get to how you see the importance of issuing a bad, false, or inaccurate grand jury subpoena.
Mr. Brooks was shot. There is an Atlanta policy that requires that the officers have to provide timely medical attention to Mr. Brooks or to anyone who is injured. But after Mr. Brooks was shot, for some period of 2 minutes and 12 seconds, there was no medical attention applied to Mr. Brooks. But when we examined the videotape and in our discussions with witnesses, what we discovered is during the 2 minutes and 12 seconds that Officer Rolfe actually kicked Mr. Brooks while he laid on the ground, while he was there fighting for his life. Secondly, from the videotape, we were able to see that the other officer, Officer Brosnan, actually stood on Mr. Brooks's shoulders while he was there struggling for his life. We were able to conclude that based on the way that these officers conducted themselves while Mr. Brooks was lying there, that the demeanor of the officers immediately after the shooting did not reflect any fear or danger of Mr. Brooks, but their actions really reflected other kinds of emotions.
Gene, I've talked to you about this a million times before, and I know each state's rules are different. But in addition to the subpoena issue, which I want you to address the importance of that, these prosecutors, look, you have an obligation to go out and give the four corners of what it is that you're, at least in my state, of what it is that you're charging so it's transparent. And anything else the media wants to know, they can find in court. They can get it by way of affidavits. They can get it by way of arguments made inside a court, but not out in press conferences like this. So I've got to start asking myself the question, if I were a defense lawyer, money payments that maybe were potentially improper, grand jury subpoenas that are illegally issued, and now him getting up there and grandstanding in court of public opinion, I'm going to make this the centerpiece of my argument as to why my client, Officer Rolfe, is charged if I were representing him. Talk about any of those things.
Yep, and I would make a motion for disqualification that I had filed a couple weeks ago in Albemarle County, Virginia. When the prosecutor's office has unclean hands, whether it's a conflict of interest, whether it's improper motives, whether it's a press conference where you went beyond the four corners of the charging documents, a prosecutor should be purer than Caesar's wife. And this prosecutor has lost the credibility argument. Now, focusing on that grand jury subpoena, I'd love to talk about that one.
Go ahead.
Oh, there you go. I didn't want to go too far.
If you could give me another Caesar's wife analogy, that would be awesome, too.
Well, I was told that when I first got hired with the Department of Justice. And what it means is, even if you don't have an actual conflict, an apparent conflict, you got to take it to another level, like Emerald the chef. And they're not doing that in Georgia. But let's go to the subpoena. I'm going to defend the DA on this one. I used to get subpoenas all the time. You give information to one of your staff. they get the subpoenas from the clerk's office. It's a relatively ministerial thing unless you're getting a subpoena from a grand jury that doesn't exist. Did the DA know that it didn't exist? No. There's no evidence that he did it willfully. And the second thing that helps him is they didn't comply with the subpoena. And once he found out it was bad, he withdrew it.
All right, that's a fair defense, but the DA did give conflicting statements. I believe it was, well, we thought that the panel pre-COVID was still in existence, so the audience understands the panels run out after a certain period of time. And then another statement afterwards when they were like, what are you talking about? That panel had ran out was, oh, well, we thought it was for the new panel that may be coming in. So there was some wobbliness and confusion, but I will grant your point. But here is the issue that I would bring out as a defense lawyer. And here are the words I would say when I would get to this point, if I were allowed to in summation. I would point to the prosecutor or the assistant district attorney who's going to bear the brunt of these mistakes and say, sloppy, sloppy, sloppy. And if they're sloppy with this, what else were they sloppy with in their rush to judgment when they didn't even wait for the Georgia Bureau of Investigation, which is unheard of, to at least come back with their investigation? Ladies and gentlemen, my client's being railroaded. Would this be a Gene Rossi kind of defense too?
Gene Rossi makes a lot of defenses. Yes, that would be a Gene Rossi defense. It would be up to the judge whether he would allow or she would allow it to be presented to the trial jury. But here's the thing. They're losing the court of public opinion, the verdict from the court of public opinion. My eyes are glazing over by the conflicts or the appearance problems with that DA in Atlanta. It's bad, bad, bad.
Yeah, Gene, you know, that's a great point. Listen, whether it's in favor of the defendant or if it's in favor of the victim, when you're dealing with the court of public opinion, the red flag should go up. You should stop doing that and fight it in a court of law. And if you want the public to understand what's going on, file your affidavits, file your motions, and all the facts come out during that and the court arguments. We got to take a quick break. We'll be right back. Well, at the top of the show, we told you that the first federal execution in 17 years was to occur at 4 p.m. The breaking news is a federal court judge has put a halt that will not occur, and the DOJ is appealing that decision. So let's break this case down. It's very interesting. Daniel Lee, back in 1996, was accused of and ultimately convicted of shooting a mother, a father, and their 8-year-old child, putting bags around their heads and then weighing them down in a bayou. A very brutal murder. He was on trial with a co-defendant in the case. The co-defendant is the person that they said was really the mastermind behind it. In any event, he was convicted and has been waiting all these years. But as many of you may know, there's been a moratorium on actual executions, and that's why for 17 years there hasn't been a federal execution. U.S. Attorney General Barr last year lifted that ban, listed 5 people that should be scheduled for execution, Mr. Lee being one of them. And this volley going back and forth all week long has been a district court saying that they stopped it, that a U.S. Court of Appeals had indicated that, no, it can go forward today at 4 o'clock. And then apparently a new argument made by a district court judge today that was accepted was to halt it based on the 8th Amendment. That is the cruel and unusual punishment standard that we have. The interesting twist of this case is Arlene Peterson, who is the mother of the woman, the mother of the mother who was killed and her granddaughter who was killed and her son-in-law was killed, has been very vocal that she does not want the death penalty in this case. Let's take a listen.
It was stated and recorded that Chevy told Daniel Lee to kill Sarah. And he told Chevy, I don't kill children. And he said, Chevy said, I do, and he did. So who's the worst man? That's the way I feel. So I was really surprised when they came out. They called us from the hotel, and asked us to come, that the jury was coming back. And the foreman of the jury said that Chevy Kehoe was sentenced to life without possible chance of parole. But Daniel Lee was sentenced to death. And yes, I believe you have to pay for what you do. But that don't mean death. I don't understand how it got so turned around. I think they should give him the same sentence that they gave Chevy Kehoe. I don't think they should have gotten different sentences like that. That's showing prejudice in itself. Yes, Daniel Lee damaged my life. But I can't believe taking his life is going to change any of that. I can't see how executing Daniel Lee will honor my daughter in any way. In fact, kind of like it dirties her name. Because she wouldn't want it, and I don't want it. That's not the way it should be. That's not the God I serve. Do I think the government should value my opinion? Yes, I'm as much a victim as Nancy and Sarah was. If I could talk personally to President Trump, I feel he could feel my heart and know that I don't want this to happen. That Daniel Lee doesn't need this any more than Chevy Kehoe does. I believe that he should give Daniel Lee clemency for what he did. Just prison without any chance of parole. I believe that putting Daniel Lee to death is not going to help nobody.
Well, Gene, I'll tell you, you get choked up listening to the context of this person who has every right to be hateful, but she's talking about her God, and she's talking about going to President Trump for clemency, and we know we've been dealing with a lot of issues with respect to clemency lately. But the interesting point that she brought out that I want the audience to understand, and Gene, you know I've tried death penalty cases, but I've come to the place where I don't believe in the death penalty because of inconsistencies, incongruities, legal anomalies. And what she's basically saying is that the leader, that Lee would not shoot the 8-year-old girl, says, I don't do that to kids. Now, they're part of this supposedly white supremacist group. And that Kehoe said, well, I do, and he shot and killed the 8-year-old. Yet for some reason, he gets life in the same trial that Lee, who did less, got the death penalty. And that's problematic to me in my mind. And moreover, and my second point is, to what extent should the government listen to the victim's family with respect to what they want? Why torture this woman any longer? I think she made a great legal point. I think she made a great personal and religious statement according to her beliefs. Thoughts?
I have never done a death penalty case, and I actually am glad I did not. As you know, Bob, they're incredibly emotional. I do know this. Any prosecutor's office that does not pay attention to the views of the victims, especially Miss Peterson, who has 2 people who were killed, her granddaughter, Sarah, and her daughter, Nancy. If she doesn't want the death penalty, I think the overwhelming weight should be in the favor of Miss Peterson, and they should not take his life. And here's the thing that bothers me about Danny Lee. Was it a horrendous murder, triple murder? Absolutely. But I do believe, just looking at this record on the surface, that I don't think he had the same type of legal team that Chevy Kehoe had. I don't think he had the varsity team. He may have had the JV. She brought up something in that clip about when he walked into the courtroom, he wasn't dressed properly. He looked guilty. Chevy Kehoe came in. He looked like a choir boy. Those are little things that great attorneys, the varsity attorneys, know affect a jury. I don't think he got the best representation. That's my view.
Gene, I was just going to raise that point, and if anybody wants to take a look at this interview, I'm sure you can find it on the Law&crime Network. Its whole interview is amazing. She brought that point up herself, that when he came in looking, in Italian they use the word scacciato, that he wasn't properly dressed, and he had the swastika on his neck, and the other guy came in and he looked clean, and he was dressed well, that she herself she says, even I was prejudiced against him from the very moment just looking at him before I heard any evidence, and you could see it on the jurors' faces too. I mean, this is what gets me concerned about the death penalty. In some cases that I've tried, whether they're death penalty or not, you are right about the A team can make a big difference in defense lawyering versus the B team and as to whether there's a conviction or not.
Now, I do got to add this, though. I've been hard on the A team versus the B team, varsity JV. But there may have been, and you know this, Bob, there are aggravating factors and mitigating factors. My reading of Danny Lee is he had a lot of aggravating factors in his background, a lot. His criminal record, his participation in the crime, and there may not have been any mitigating factors that were presented or were able to be presented. We don't know all that.
Yeah, no, that is a fair point, Gene. But I want to go a little bit more back to the cases that I've handled, the murder cases, whether they be death penalty or not. We took very seriously the victim's desires. In fact, I remember one death penalty case I handled at trial. They wanted to take it out of the death penalty. They wanted him to spend the rest of his life in jail under horrible circumstances, as it were. And a lot of defense lawyers bring out the idea in death penalty litigation that life in prison is worse than death. What are your thoughts about, again, getting back to that idea that we are much more victim responsive today than we were 20 years ago?
Oh, absolutely.
It's an old lady. It's an old lady, That's what would get me if I were the president. Why would I want to bring any more trauma into her life?
Absolutely. She brought up a good point. In her mind, the death penalty for Danny Lee is going to sully the memory of Sarah and Nancy and Mr. Mueller. Don't forget the husband. He also got killed. And those three's names, their names will be sullied by this execution in her mind. But I got to say this, the argument that life in prison is not a cakewalk is getting more and more weight now in federal court and state court.
All right, Gene Rossi on another special segment of Law and Crime Network, Keeping the Peace. I will be back tomorrow with some more great information. You have a great day. Stay with us for our regularly scheduled programming.